Hey everybody, how are you? So I'm sure by now most of you have heard that the Supreme Court decided that Trump cannot be removed from the ballot for having participated in an insurrection. I've been doing a lot of thinking on this issue since it got into the news a few months ago, and that was when the case actually started making its way through the Colorado courts. And by the time the final opinion came down, well, let's just say I've got some feelings on this issue. So it's been hard, really hard actually, for me to figure out how I was going to do this video, because a big part of me wanted to go through the whole ruling line by line, dig into every court case and law mentioned, and just get really deep into the legal weeds of why this is such a damn mess. But I realized that was just going to drive everybody crazy. Instead, I'm going to try to do something a little different. I'm going to explain the important details without going overboard, just so everyone understands the background, but I want the focus to be something a lot bigger than just the ruling in this one particular case. I want to talk about institutions. So what are institutions? We hear the word a lot, but what does it really mean? An institution, as I think of it, has a couple of key features. An institution, 1, is made up of many people. 2, has a specific purpose. 3, has internal rules, regulations, and hierarchies. 4, has some ability to influence or regulate society. And 5, it persists over time, and the membership varies. As somebody leaves, someone else comes in. So let's take a look at a few examples. The Beatles, or any other band, are they an institution? Well, we've got a group of people, and they have a purpose, it's to make music, but they fail on all the other tests. There isn't really a hierarchy, and while plenty of people listen to them, the Beatles didn't really have any authority to tell society what to do. Finally, once the band members die, no more Beatles. What if we're talking about a football team, like the New York Jets? They got many people, they have a specific purpose, there's internal rules and a hierarchy, more or less, since there are the rules of the game and everyone on the team has their own position, and it does persist over time, because when one member retires, another guy comes in. But they have no ability to tell anyone else in the broader society what to do, so the Jets aren't an institution either. The NFL, on the other hand, is a stereotypical institution. They actually can set the rules, not just internal rules for how the NFL operates, but also rules for how every team plays the game. Without the NFL or something similar, it would be impossible for national level pro football to work at all. Someone has to set the rules, someone has to keep the scores, etc., else it's only a matter of time before somebody starts filling footballs with sand and putting spikes on helmets. So why am I talking about this stuff? Well, it turns out that running a country is a bit more complicated than playing football, and as such, institutions are even more necessary to keep things from spinning into total chaos. This is especially true in democracies, because in a dictatorship, the dictator is the only real institution. For example, in the Soviet Union, they had courts in the 1930s. They existed, but they were incredibly weak and corrupt because it didn't really matter that the law was carefully and accurately interpreted. The law was whatever Stalin said it was. In the US, however, things are different. We rely on our institutions for everything, whether we notice it or not. It really matters when you go to pick up some medication from the pharmacy that the FDA has confirmed that's what's in those pills is what's supposed to be in those pills instead of sugar with some food coloring. It's really important that when FEMA tells people to evacuate to a certain safe area that there's food and medical care ready and in place for those people. And it's also really important that when a court makes a ruling on something, that they're following the law as opposed to their own political or personal interests, regardless of who is sitting on that court. Moreover, because we live in a democratic society, it's incredibly important that the people see that institutions are doing what they say they're supposed to do. If the people lose faith in those institutions, it becomes easier for politicians to ignore them or even destroy them. Keep that in mind for a little bit. We're going to head back to this later. So now we want to get back more specifically to focusing on this Trump ballot case. And this all started out when two of America's top legal minds, Judge Michael Ludick, he's from the right, he's a conservative, and Judge Lawrence Tribe, who's a liberal, Professor Lawrence Tribe, they started looking at the Constitution's 14th Amendment. So the 13th, 14th, and 15th Amendments were all passed during the Civil War, and thus they had a lot to do with slavery and voting rights and insurrection, Specifically, Section 3 of the 14th Amendment goes like this. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or any other state, or under any state, who having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. Admittedly, there has not been much reason to use this section the last century or so, but then after what happened on 1/6/2021, it became all too relevant. For the first time since the 1860s, a group of American citizens tried to violently overthrow their own government, and the ideology they were following wasn't too different from what drove the Confederates, and they weren't particularly subtle about it. Those were MAGA 1/6 rioters, and yes, that was a Confederate flag. What made 1/6 different from the Civil War, however, was that the attempted insurrection was instigated by the sitting president himself, Donald Trump. And then, in another unprecedented move, that same guy is now running again to return to the presidency. So Ludigan Tribe wrote an article, there's a link to that in the description, explaining why the Constitution prohibited oathbreakers and traitors from returning to the halls of power, and that maybe giving this guy power again might be a bad idea. So this argument was taken up by a group of litigants in Colorado, Republicans, by the way, who sued to get Trump taken off the ballot. Their argument was that, as Republicans, they had the right to a candidate who was actually eligible to be president, and that Trump should thus be removed. And originally this was taken up by the district court in Colorado, and that court came to the conclusion that, by a preponderance of the evidence, Trump did commit an insurrection. However, this court kind of split the baby by saying that even though he was an insurrectionist, Trump could stay on the ballot because while the 14th Amendment prevented any officer of the United States who broke their oath from being on the ballot, it did not apply to Trump because the president is not an officer. That is, in legal terms, stupid. I've read all the legal justifications for this claim, that some people were saying that it rests on the minute differences in the wording of the oath for congresspeople versus the president, but I'm not going to bother anybody with that because, again, it's stupid. The presidency is in office, and the president is the chief executive officer of the executive branch. Moreover, it's just hard to stomach the idea that the guys who just fought in the Civil War would be totally cool with the president being a traitor. Personally, I think that in this case, the judge made the decision she did because being the one to remove Trump from the ballot would mean an instant barrage of extremely graphic death threats against her and everyone in her family, which is what has happened to literally everyone else in the legal system who has opposed Trump in any way. But that's a conversation for another day. So the Supreme Court of Colorado, they got the case on appeal, and they came to what I consider to be the correct decision. The president is an officer, and this particular officer participated in an insurrection, so he's no longer eligible to hold that or any other office ever again. Now, before I continue with the history of this case, I want to clarify something that often gets lost in the discussions around this issue. When I first heard about the effort to remove Trump from the ballot, my first instinct was actually to oppose it. I do believe that the best possible option for the future of our democracy would be for Trump to get absolutely annihilated at the ballot box, a crushing defeat that would be a loud message from the American people that we aren't with this guy. A Biden landslide would show that the American people aren't in favor of constant lies, raging bigotry, performative cruelty, fraud and abuse, ignorance and authoritarianism. However, to be absolutely clear, that is my political view. I think it would be politically better for the country to say, no, we don't want to be serfs in the kingdom of Macedonia until Donald Trump the 19th. However, politics and law are not the same thing. We have to be careful to separate out what we believe to be the better political result from what the law actually is. And I know that this is hard, but as we go forward, try to keep that distinction in mind. It is really important. Alright, back to the case. So the case is now with the Supreme Court, And there is one issue with which they agree with both lower courts, or at least they don't disagree. Donald Trump is an insurrectionist. The events around 1/6/21 were an insurrection, and Trump was at the head of it. That was the original conclusion of the district court, using evidence that it reviewed and a good chunk of info gathered by the 1/6 committee. I know I've said this before, but I'll say it again. If you haven't watched those videos, those hearings, watch them. It is not boring, and the details are really crazy. I'll put a link there in the description as well. It's worthy viewing for every American. Anyway, the district court ruled based on the preponderance of the evidence, right? The district court is the original court that made the ruling on this case. That essentially means that it's more likely than not. I realize that most of you are used to beyond a reasonable doubt, but that's for criminal cases like the one Jack Smith is handling. Civil cases tend to use preponderance of the evidence, just like this one. However, in this case, it is a heavy preponderance, okay? This is just coming from me. You know, between the 1/6 hearings and whatever comes out of the court filings from Jack Smith and Fani Willis, what Trump did is incredibly and overwhelmingly clear. The evidence in the public record is enough, I think, to convince any reasonable person of what he did, assuming that the person actually watches that evidence, which is another story. Now, SCOTUS apparently shares my opinion on this issue, or at least, like I said, they don't oppose it. They just left it at that. They did not in any way touch or overrule the previous two courts' opinion that Trump was an insurrectionist. They're like, cool, he's an insurrectionist. But they have put him back on the ballot, and they did it with a technicality. They said that Trump couldn't be removed from the ballot not because he wasn't an insurrectionist, but because the states didn't have the authority to enforce Section 3 of the 14th Amendment on federal officers, only on state officers. They also ruled that in order for anyone to be disqualified this way, Congress would have to pass some sort of specific new legislation to disqualify that particular person. This ruling, as I've said before, is just dumb. And I'm going to try to give you an idea why without getting too insanely deep into the legal weeds of this. And there are a couple of main points that SCOTUS makes, and I'm going to try to pick them apart one by one. To start, the court repeatedly leaned on the assumption that the 14th Amendment was about rebalancing power between the states and the federal government. I don't think that's really true. I think that a more nuanced and really far more accurate reading of the 14th Amendment is that in establishing equal protections under the law for all citizens was about rebalancing power in favor of the individuals that the Confederate States had harmed, namely enslaved African Americans, and they weren't too nice to the free ones either. It also, in Section 3, protects individuals from ever again being under the power of the people who had attempted to take their rights in the past. The 14th Amendment is about protecting people, not increasing the power of the federal government. Now, moving forward from this premise, which is already wrong, the premise that, the 14th Amendment is specifically about limiting state power, SCOTUS uses that to justify another point, which is also wrong. And SCOTUS was claiming that allowing the states to remove insurrectionists from the ballots for federal office is an expansion of state power, and that the states would be imposing a qualification for a federal officer. This is also wrong. Firstly, as a matter of law and fact, the states already have plenty of power in federal elections, as they are in charge of the manner in which the elections are executed and carried out. The not being an insurrectionist requirement for holding office is not being imposed by the state, any more than the requirement to be over 35 and an American-born citizen for the presidency. Those are federal requirements. The states just act on that. There's actually a pretty ironic example that would be helpful here. Some of you might remember that the last time presidential qualifications were such a big deal was back when Obama was running. Oh yeah, back when Trump was really big on only qualified candidates running for president. That's why he started the whole birther conspiracy about Obama being born outside of the U.S. And I've got Obama's birth certificate in the description, as I have had use for it in many conversations, let's just say. So, let's say that we're all temporarily transported to another reality where Trump is actually capable of telling the truth. In this reality, Obama really was born in Kenya, and in that instance, depending on the state, there might be slightly different processes, but someone would have sued challenging his candidacy. It would be established that his birth certificate was from Kenya or wherever, and he would have been removed from the ballot due to being ineligible. Same as if I were to run for president. I'm 27 years old. I'm not eligible. And the Secretary of State of New Jersey would not let me on a ballot. They're just enacting the rules that are set up in the Constitution. They are not creating those rules. And those qualifications are not up to the states. If a state wanted to let an insurrectionist run, that's not up to them. The states are just acting on the qualifications the Constitution lays out. So to sum up what we've got so far, SCOTUS is saying is that the 14th Amendment is about strengthening the federal government against the states, which is wrong. It's about protecting individuals. And that allowing states to enforce the 14th Amendment would be increasing state power by giving states the ability to set qualifications for federal officers, which is also wrong. SCOTUS then goes on to argue that because the 14th Amendment allows Congress to create legislation to enforce Section 3, that they now must create some form of legislation for Section 3 to be enacted. But that's not what it says. For years, the conservatives on the Supreme Court have been telling us how it's so important to follow every word of the Constitution with its original meaning. But now they just make stuff up. Now, admittedly, that's not really new. There have been many cases where they've gone down this particular road of hypocrisy, but, again, a conversation for another day. So Congress can make legislation to enforce the 14th Amendment, and not just Section 3. They have done this in the past. In fact, Trump is currently being prosecuted under those very laws, called the Enforcement Acts. There are 3 of them. They were passed after the Civil War. And those acts also have disqualification as a penalty for various violations of 14th Amendment principles outside of just Section 3. And if Trump were to be convicted there, he would definitely be disqualified. But it's not necessary for his disqualification, nor is it necessary for Congress to pass any additional legislation for a disqualification to be active. All that is necessary is for him to have sworn an oath as an officer, and then broken that oath by engaging in insurrection or assisting those that engaged in insurrection. It would be certainly nice if Congress could enact more laws in future to clarify this situation, but that's not the world we live in, and it's also not necessary. One particular line of importance in the amendment is where it lays out a process for removal of the disqualification by a 2/3 vote of Congress. But if the person isn't disqualified already by the 14th Amendment itself, what would they be removing? An insurrectionist oathbreaker is already disqualified by engaging in insurrection. The disqualification is self-executing and provided for by the federal Constitution. The state official is merely recognizing that fact and carrying it out in their election process. And that bit, at least I will say, is something that the minority dissent in this case, they completely agreed with. They said this almost exactly. And it pretty closely matches exactly what I was thinking. However, both the minority and the majority agreed in their fear of one main issue, that this would result in a patchwork of cases in different state courts under different rules. Now, if only there was some sort of body that was above all of those different state courts and could then make judgments about those cases to see which ones were legitimate and which ones weren't, almost like a set of super judges, and they'd have their own court. And oh wait, that is literally your job. That is literally what the Supreme Court is for. when there is a mishmash of rulings from different states. They are there to fix that. However, there's something deeper that runs through this ruling that I think really shows the rot in our court system. I can imagine exactly what was going through the judges' heads as they were thinking through this ruling. They were thinking about the kind of threats that were being made daily on Fox News. How if Trump was removed as an insurrectionist for 1/6 in one state, then some judge in Alabama or Texas would rule to have Biden removed, saying that his border policy is an insurrection or that wokeness is an insurrection or something like this. However, in our system, there's supposed to be something that stops the courts in various states from acting in this way, and it's called reality. There are actual facts, and it is one of the main functions of our legal system to be able to establish what those facts are. The fact of the matter is that Donald Trump did try to overturn our political system by disrupting the peaceful transition of power for the first time in a quarter millennium, and Joe Biden didn't. That's it. End of story. Finish. Done. The fact that not for one solitary second did the highest court in the land consider that our court system might be rigorous enough and unbiased enough to withstand these kind of political shenanigans is a real indictment of the court. And I believe that this is largely the result of the court itself, under John Roberts' direction, becoming an instrument of these same political shenanigans. Leave aside Bush v. Gore, where they handed Bush an election based on nothing. Leave aside Shelby versus Holder, where the court just upended a chunk of the Voting Rights Act because the conservatives thought it was old, while at the same time arguing that the Constitution has to be read as it was in 1790. Justice Clarence Thomas's wife was a direct participant in the 1/6 coup attempt, and he had been ruling on those cases without recusal, while simultaneously receiving bribes from a billionaire in whose favor he'd ruled before. Look up Harlan Crow if you're unfamiliar with that story. The court system has lost faith in itself. And I was saying earlier that it's important that an institution be seen to be doing the function it's supposed to be doing. And here it seems that the court is totally okay with doing politics, as opposed to doing law and making legal judgments. In fact, let me give you an actual line from Justice Amy Coney Barrett's concurring opinion. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writings on the court should turn the national temperature down, not up. What? I bugged out when I first read that. What the hell is she talking about? National temperature? Lady, you were a Supreme Court justice, not the goddamn weatherman. And you weren't a political pundit either. And it is the fact that the court sees itself in this way, and sees no problem in seeing itself this way, is just unbelievably dangerous to our democracy. Thank you guys. That's all on this one. See you next time. Bye-bye.